right, here's a good one, here's a good one. Thank you. Perfect.
That's an old special line that already.
With that
It's
first
already
line.
about pretty well, so he's done really well at it. It's great, as far as I know, it's just local, but they do have a few other shops that are just in Denver. So they've been trying to move it up to like a project manager position. Let me get a little bit more. So he's doing well with it. He's contemplating starting her own place. Yes, she's my wife and her are looking at testing all around. My daughter's been back in and she was doing it out there. She started a new shop, basically, a new coffee shop. And they had it on Facebook. Wasn't a claim to she's exploring, now she's exploring.
We may need a few more chairs.
Patients, ideas are still kind of building their project out there. So they want to have, she's working
Yeah.
exploring that person, there are different companies there's a reason that does right now, it's my daughter,
Yeah.
daughter's been dating back about 6 years now, so she came back and visited.
That's my daughter's 24, 8, 25.
So the daughter's been living together for years. 27 and 25. That's right, I do remember your son. Did you watch it?
You and I have met.
We were there on Sunday, right?
Okay.
My daughter on Saturday, and I
Yeah, so I looked at it and she was about my mom. Oh yeah, it would be. But I thought they had on date night if you moved up to 19. And I'll have to.
Okay.
Like I must.
It's hard to get back.
back into the group.
That's one. Dementia.
That's what was sold place.
Oh, that's You're
You were popular. What's this? Are we picturing?
Yes, you are. You're excited.
Let me just talk.
It's not fair.
Yeah, I do too for my mom. Thank you, Brad. I just don't want to know that.
Okay.
Find a place to sit. There's a place in the back of the room.
How are you?
Good. Thank you. The rowdy ones in the back.
The rowdy people. Oh no.
Yeah.
Well, whenever you need me.
Thank you. Here, so Brandon,
All right, don't tell her, don't tell her.
Not the
Encouraging. He's good to talk about.
All right, we're gonna get started to be mindful of time. Okay, all right, that's what I'll do, okay. Renata? Okay.
Hi, good to see you.
Good to see you.
So I'm Kimberly Diaz, I'm part of the Transition Living Network team, and we have our other teammates up here. We have Sherry Cree, we have Renata Anderson, and Cara Riley. Kelsey isn't here today, but she's also part of our team, and we will be putting on monthly events for you here at the library. And we've got all the brochure of everything that we're doing. And we've got Brian here, I'll do his introduction in just a moment. And we're gonna get started, and then I wanna introduce Thomas. He brought all of our lovely snacks today with Lifeway Mobility. So he'll tell you a little bit about what they do, and we'll get started.
Thank you very much. Hello, my name is Thomas Schumacher. I'm with Lifeway Mobility. We work with people trying to stay in their homes. We work everything from stair lifts to elevators, full bathroom remodels, to just small portable ramps, handrails, grab bars, that type of thing around the home. Anything outside of typical DME, which is durable medical equipment, everything just outside of that realm. So we're not working with wheelchairs, but we are working with wheelchair ramps, wheelchair lifts, that type of thing. So I did leave a few brochures and a few folders over there. If you have any questions, just let me know.
What is your company?
Lifeway Mobility.
Lifeway.
We've been Accessible Systems for about the past 20
Oh, I knew it
20
as
years.
accessible.
Yes, Accessible Systems has been around since about 2000 or so. And the same three gentlemen that started that company are still with us. We merged with Lifeway Mobility about 3 years ago, a company out of Connecticut. We were building the first national brand of company that does this. No one else does it. Everybody else that does this type of work, for the most part, they're mom and pop shops, which is fine. But once they stop doing it, then where are you gonna go for service, that type of thing, so.
Would you share the address of your showroom?
You bet. The address for our showroom is down at Camden and Federal. It's 3025 West Jefferson. And actually, interesting note about the show home, we call it a show home versus a showroom. It took me forever to get that. Now I can't say showroom. But the interesting thing about the show home is it's actually, I believe, the largest accessible show home in the country for any type of accessible place. Sherry's actually been down there. It's quite an amazing place, really. We used to have 4, now we actually have 5 different stair lifts that you can actually sit on and ride, see how they work. We have one working elevator. We have a couple different ones that are set up. Different types of elevators. We have some that are standalone, some that are traditional, like you would think of inside, someone maybe had built a pantry or closet at some point and do a straight up like just a regular elevator. We have a stilts elevator, which is when it goes upstairs, all you see are a couple poles down this room. When it comes downstairs, you see just a couple poles, hence the stilts. So full bathrooms in there that we remodel. We do ceiling lifts for people with those types of needs, picking someone up from their bed, carrying them to a bathroom, to a living room, anywhere throughout the house. So all those working models are there in our showroom.
So it's kind of an amusement park for the plus, right?
So we work very closely with Greg Hospital and Swedish Hospital as well. So a lot of times Greg will just show up with 3 or 4 people and a couple of their administrators and just start showing them around our place without even, calling us to say, hey, we're coming. They just come and look because it's just so open and inviting, you can just come and see. It's very interesting, very neat place. So.
And you have catalog information there.
I do have a couple catalogs over there, some folders, that type of thing. If there's any other questions, just hit me up and let me know. I have a few other things with me that I could share if someone would be interested. So.
Thank you.
Thank you, appreciate it.
I also just wanted to take a minute and maybe a moment of silence for California. I'm supposed to fly to LA Friday. I'm not sure if it's gonna happen or not, but Palisades is basically gone. The fire is really devastating, so if we could just take a moment, I think that'd be appreciated. Thank you. All right, Brian. So Brian Frutig is the managing member of Frutig Law LLC. It's a boutique estate planning and elder law firm based in Broomfield, Colorado. They serve clients in Colorado, California, the District of Columbia, Ohio, and New York. Brian primarily helps clients with basic estate planning, wills, revocable living trusts, powers of attorney, advanced directives, living wills, and non-probate transfers. Complex estate planning, tax planning, charitable giving, supplemental needs planning, and estate protection. Elder law, he helps with Medicaid preparation, including Medicaid asset protection, trusts, and Medicaid income trust, and trust and probate administration. He enjoys the close partnerships he develops with his clients and always strives to help preserve family relationships and avoid unnecessary conflict. I do have the honor of working with Brian with several of my clients, and it's been a very positive experience, and he's a stand-up guy and wears his heart on his sleeve. So, thank you, Brian.
Thank you so much, Kimberly, thank you. Good morning, everyone. How's everybody doing this morning?
Great.
Excellent, I love the energy. I didn't realize I was speaking to a live stream as well. So I'm being, for better or worse, I'm being pushed out to the world. It's always nice to get a nice introduction, but it's always easy when they let you write it yourself. Thank you to all of you for taking time out of your morning to be here. As I'll probably repeat a number of times, this presentation is for you. So I'm gonna, in the beginning, try to take the temperature of the room to try to understand more about what you guys are looking to do. Before I get started, I just want to say again, thank you to Thomas for the spread. Thank you to the Traditional Living organization for helping all of your clients. You guys really are the frontline people that help, people that I help in elder law. What I do is a small piece of a larger puzzle that we all are trying to put together. I know that too well from my own personal life, dealing with my parents and my clients. So if anybody in the room is a caregiver, you guys are also really the heroes here. And I hope something that I say today is gonna help make your job a little easier. The remit of what I've been asked to talk about today is broader than last year. Last year I spoke exclusively about Medicaid and Medicaid preparation and Medicaid eligibility. This year I've been asked to also talk about estate planning. I've been given about 45 minutes to do that. It's impossible to cover both of those subjects in 45 minutes. So I guess just by a show of hands, are you all in the room? And I apologize if anybody who's watching online, apologize you can't vote on this. Are people more interested in learning the basics of wills and trusts and powers of attorney? Or are we more interested in learning about Medicaid eligibility, how Medicaid works and operates, and how they look at income and assets?
So, the first.
So for people that are interested in basic estate planning, please put your hand up. All right, so we've got 5 or 6 of you, and then for Medicaid, all right, so we got a pretty even mix. So what I'll try to do is I'll try to cover them both about even. My promise to you is that I will stick around after this meeting to answer as many questions as you have. If people have specific questions and want me to talk to a subset of you, I'm happy to do that. If you want some one-on-one conversation, I will literally stick around for hours to do that. So let's get started. Standard lawyer mumbo jumbo. The joke is being covered by the sharing screen. I apologize. I speak both mumbo and jumbo. This is purely for informational purposes. This does not constitute legal advice, and no attorney-client relationship is established by this. So here's the agenda that I like I just said is probably broader than I can actually go through everything in detail. I'll try to cover it about equally between the first bullet and the third bullet. The second bullet's kind of more for informational purposes anyway. again, we'll cover this incredibly quickly. So as Kim said, my practice is based in Colorado. About 70% of my work is here. The remainder is split between California, New York, and DC. And my business partner is based in Ohio. So anybody that has connections to Ohio or is moving from Ohio to any of these other states, we can help with. I call this my hub and spoke model for what areas of law I practice. Estate planning is the hub. Almost everybody's plan is built around the documents that organize their affairs and who they appoint to assist them when they need it, whether that's in death or during life. All these other areas around it are things that are natural offshoots, whether it's probate or trust administration or elder law. I use some business law to help clients with closely held entities make sure they're properly structured and managed according to laws. Real estate and marital agreements a little bit, but I'm doing less and less of that. So hopefully that just provides you a little summary of who I am. Little pieces of my personality will probably come out during the presentation. I try to make this as informative in that way as possible. So this is the fairly standard question that is a good icebreaker for everybody. I just gave a little punchline. So who in the room here has a will or has an estate plan? Okay, so we've got nearly everybody, which just warms my heart because by the numbers, most people don't. Numbers are about that 30% of people in society have a will or have an estate plan in place, which means that 70% of people don't. And that's kind of scary, and that's what causes a lot of conflict and bad experiences with end-of-life transfers or challenges during life to help somebody manage their affairs. The bad joke is that everybody does. Everybody in here has one. If you think you don't have one, you do have one. The state of Colorado or the state of New York or the state of California draft one for you. In many circumstances, it doesn't do what you want it to do, so that's why you should do it yourself or talk to an attorney, and I can kind of give you guidance on how to do it either way. The question I get a lot is who needs an estate plan? The answer is pretty much everybody. If you've turned 18, so if you have children or grandchildren that have turned over the 18, even they need some basic components of an estate plan. The part that I focus on for people who are just 18 is powers of attorney. So what I mean by that is usually those fall into two forms. One's called a medical durable power of attorney. And that's a document where if you are incapacitated or you can't make your own medical decisions, you appoint somebody else to step in and make those for you. So again, if you're over the age of 18, it makes sense to have that in place. Same for managing financial, that's called a general durable or a financial power of attorney. And that's an analog to the medical. It's somebody that can step in and pay your bills, can manage any property that you own, whether that's real property or bank accounts or tangible property like things. I'll have a slide about that later. All these other aspects are markers where people may want to, maybe an impetus to do one, or may be an impetus to change what they have, to update it. That can be, are you in a new relationship? Are you married? Do you have children? Have you decided to bring firearms into your home? Are you remarrying or divorcing? These are all points in time where you would want to do that. So, before I get into the page, I think the easiest way to summarize estate planning. So the next bit's going to be for those of you that are here because you want to know more about basic estate planning. For those of you let's make this to everybody in the room. Are people in the room interested in learning more about where do trust? Are trusts a thing that people are very interested in? Okay, got a handful. Let me ask this question: do people feel like they understand what a trust is? We got one nod in the back. No. So
There we go.
I love it. Thank you. So here's what I want to do. I'm actually going to stop before we get into these. I'll leave it on this slide so you guys can see something beautiful on the picture that's on the screen and pay attention to something that's not me. Writ large, I look at estate planning as having two types. There's a will-based estate plan or a trust-based estate plan. A will-based estate plan is the simplest kind. to draft. It's the simplest kind to organize. The way that a will-based estate plan is given life at the end of somebody's life, not very eloquent, is that there's something called probate. And probate is a word that most people don't understand. It's kind of a scary word and has lots of people telling you that you should be afraid of it because it's costly and it takes a lot of time. What I'm here to tell you is that really kind of depends on what state you're in. And since we're here in Colorado, of all the states that I'm licensed in, and candidly, all the states that I'm aware of how their probate system works, is the most efficient probate system around. And it's not as scary as, say, if you lived in California or New York. So if we were in California or New York and I was giving this presentation, I would have a very different message about who I would consider for a trust-based estate plan versus who I would consider for a will-based estate plan. Probate here is just really efficient. A will-based estate plan includes the following documents. And the reason I'm listing all these now is to try to give you an idea of what each bucket looks like. A will-based estate plan includes a last will and testament. That's going to be your organizing document for your affairs when you pass away. The main elements of that we'll talk about in a bit. The document that goes with the last will and testament is called a personal property memorandum. And that's a document that I really encourage my clients to utilize because most conflict dealing with end-of-life affairs doesn't have to do with real property. It doesn't have to do with bank accounts because those things divide evenly, usually. It has to do with things. All the things that somebody accumulates during their life that people get emotional attachments to or that have remunerative value or pecuniary value. A personal property memorandum is a great organizing tool to say exactly who you want to get those things. So I recommend strongly that people use that. Those are the two documents that deal with end-of-life affairs in a will-based estate plan. You can include trusts that come into existence on death, called a testamentary trust, in a will, but most of the time I don't recommend that, particularly in Colorado. Those are end-of-life documents. During life documents, these are called powers of attorney or ancillary documents, and these are documents that you have in place while you're living to make sure that you have the right team in place to support you when you need it. So I gave you the preview of that when we talked about the medical and financial powers of attorney. So those are two of the documents, a medical power of attorney and a financial power of attorney. I also recommend that people have something called an advance directive for medical surgical treatment. You may be more familiar with the term living will. Getting some nods. I don't like the term living will, and the profession is moving away from that because most people can't distinguish between a living will and a last will and testament. And they do totally, radically different things. A living will, which I'll get into in more detail in a bit, is a document that takes certain decisions away from your medical power of attorney and is you putting in black and white on a piece of paper what you want doctors to do in a certain situation. Okay? So really, it's some people like to refer to it as the pull the plug document. I find that both scary and euphemistically not accurate, but that's what it does.
Yeah.
The other medical documents that I recommend people have are something called a HIPAA authorization, which is a separate document from your medical power of attorney that lists a number of people that can review medical records and talk to your doctors to get information, but it doesn't give them any decision-making authority.
Sweet.
Okay. And then the last document that I'm increasingly doing for all of my clients is something called a dementia directive. And a dementia directive really deals with one small loophole between your advance directive and your medical power of attorney. Deals with primarily with hand feeding. So if you have an advanced demented state, whether it's Alzheimer's or dementia with Lewy bodies or any of the other forms of it that Kimberly can tell you about, because she understands that I don't. Basically what it says is, in advance, do I want to be hand-fed or not? Because what can happen is you can end up in a memory care facility, even if your advance directive says, I don't want to be kept alive in certain circumstances, they will continue to try to hand feed you according to their policies. You can be kept alive for 9 months, 2 years, at great cost. I mean, the great cost of memory care right now, I think this number is current, it's about $8,000 to $12,000 a month. If you're in full nursing home with memory care, it's even more. You can erode in a state really quickly by doing that, so that's why I add that. So that's your will-based estate plan. That's a basic form. When you list off all the documents, it sounds a lot more complex and scary than it really is, but that's one way to go about dealing with your affairs. A trust-based estate plan, on the other hand, all the documents are the same, so you get all those included, plus you add a revocable living trust on top of that. And a revocable living trust, and here's where I get into some legalese that I will try to say and then back off. It is a non-probate transfer, which is a term that most people don't get, and I don't blame you for it. Candidly, most lawyers don't quite understand how non-probate transfers work. Basically, the way a revocable living trust works is you create it while you're living, you title assets in that trust, so you can think of it as a bucket, you're putting things into that bucket, and then you're appointing somebody to control those things that are in that bucket. And while you're living, that's you, or you and your spouse. If you're married, on the death of the first of you, the survivor gets to control all the things that are in that bucket. So you're not really giving up any control or access to those assets. The big difference is when the second of the couple, or if it's one person trust, if the one person passes away. You then appointed a successor to step in and manage those affairs. That occurs by operation of law. It just happens immediately. There's no need for the probate system, meaning the state of Colorado, to get involved. Okay? So it can be a much more efficient way to manage your affairs. There's always a cost trade-off. So the cost to build a trust and to do them is much greater. And really, clients, that's what estate planners like me do, is we like to talk through the pros and the cons of those. So I'll have a slide later about that. Reason I started this way is I didn't want to get into the weeds of the will before we kind of painted those two pictures. Let me stop there. I have one question. Yes, ma'am.
Yeah, you do.
Great. I love questions. Please put your hand up and interrupt me, and I will. This again, like I said, this is for you.
I thought that if you had a will, probate didn't apply.
So no, that's not correct. So there are two types of probate.
I don't even know exactly what probate is.
So let's stop there. What is probate? Probate is a legal process by which assets are transferred from a decedent to lawful recipients of the decedent's affairs.
Okay.
And there's a process that you have to go through, starting with the filing of a petition in the state to have somebody appointed to manage those affairs. The person appointed in Colorado is called a personal representative. It's a synonym for executor, so people are sometimes more familiar with that. And then there's a bunch of steps you have to go through, like who you have to tell about it, what form you have to give of what assets are included in it, who you have to give notice to, so that's going to be creditors usually, and then at what time are you, and then there's a bunch of timelines about when you're allowed to start giving things out. Okay.
What if you name an executor?
When I said there's two types, there's probate. In Colorado, fortunately we're getting away from lots of language that came out of English common law. In Colorado, we have really artfully probate with a will and probate without a will. Probate without a will is this horrible term called intestacy. And that just means that's when they apply the will that the state writes for you. If you write your will, that supersedes what the state wrote for you. So in your will, you nominate somebody to be your personal representative. Then a court has to appoint that person that you nominate. And the way that the statute works is it says, if you have a will and you nominate somebody, that person has priority to be the personal representative. So it matters a lot that you have a will and that you appoint somebody. That doesn't remove the necessity to then file the petition with the court to have them say, yes, you are the person, and to give them the document that gives them legal authority to do the things that they need to do. That's called letters testamentary. Yes, ma'am. So,
What's an example of the will that the state will write for a person?
So the way it typically works is as far as, so it's just a fact. We all have a will. The state of Colorado says, if you die, here's the process of who gets appointed as your personal representative, and here's who has priority to receive your affairs, your assets. On the personal representative side, the order of priority, and I may not get this 100% right, but roughly it's spouse first, then children. If there are no children, it's parents. If it's not parents, it starts to go sideways, it goes to aunts and uncles and things like that. So that's the order of priority of who would get appointed to manage the process. And then it's a similar process for who receives the things. And again, I try to not get too caught in the legal words, but it's hard to avoid in this space. If you've heard the word heir, an heir is somebody who has a right to inherit according to state law. That's what heir.
Could you spell heir so that it's clear?
Yeah, so it's H-E-I-R. So if you are an heir of somebody, that means that you have a right, but under the law, to information or to even receive things from somebody's estate if there is no will. The reason I stumbled over notice is even if you have a will, so let's say I have, let's use my family as the example here. I don't have any kids, I'm married, I have a whole bunch slew of nieces and nephews. My will, if my will is written, gives all my stuff to my nieces and nephews, so an adjunct of my family tree. I still would have to give notice, my parents are still living, so I would still have to tell my parents or give my parents notice that probate process is going on. That's what I mean by the difference between who has a right to information and who has a right to receive things. Okay. I feel like I lost the audience a little bit with that. I got some glazed eyes. Did I answer your question before I move on?
No, I think I just wanted something simpler, like as a single or married couple with a couple of children, does it automatically go to the children?
That is the default under
Under
Colorado
yes.
law. That is the default. It's different by state. California in particular would be different. But here, if you're married and your spouse survives you, under Colorado law, the default would be that your spouse gets everything. If your spouse predeceases you and you have 2 children, everything would be divided equally between your children under Colorado law. So if that's your goal, you don't need a will. Or I mean, there may be other reasons to have a will. You may want to appoint a different person to manage things, or you may want to, I don't know, if there are minor children involved, a will is where you appoint guardians. So there could be other reasons to do that, but if you're only concerned about distribution of assets, and the state of Colorado's plan meets your goals, then you could be fine.
But with a will, if things are fairly clear cut, there's no probate involved?
There's still probate involved.
Okay.
You would still need to go, what I mean by probate is you would, just to be clear here, you would still need to file a petition with, what county do you live in, man?
Adams.
Do you live in Adams County?
Adams.
Okay, so you would open probate in the district court in Adams County. You would file a petition for probate with a will. And this is where you start getting into more of the details. We do it informally, and so that would mean that it's a faster process. There won't be any hearings or judge involvement. It's all going to be rubber stamped by the registrar, provided there are no hiccups or challenges. So that's what I mean by the process here is pretty easy. But you would still need to file the petition. You would still get letters testamentary, and that would give the person that you've nominated, the spouse, the person, to do the things that they would need to do.
Without a will, does probate cost more? Does
No,
it
it's
take
about
more
the same.
time? Does it, anything?
It's about the same. I mean, the cost of probate getting expensive has more to do with conflicts and people challenging it than it does with the process itself.
So if you just want everything kind of divided equally, you actually don't need a will?
Again, if the default plan fits your needs, you don't need one, no. I have some clients that come to me and say, I want everything to go to my spouse, or I want everything to go to my kids, and there's no complications. I say to them, you can let the current plan that you
Yeah,
have
I hate
ride.
that you made her right, but okay.
Sisters, I apologize.
I'm always right.
I'm happy to come back to probate again later, and like I said, if people want more about probate, I wasn't gonna cover probate in super great detail today, but I'm happy to talk, if that's where we go, I'm happy to do that as well. I do have a slide for that, yes ma'am.
Can you explain the difference between a small estate that doesn't even require probate?
Sure. So let me do this. Give lawyers, so I'm not sure how great, and that number on the left is actually wrong, I didn't update that. So we talked about the difference between probate with a will and without a will. All of these can apply to each of those. So this is what I mean by the process isn't really different. So the question is about the type of probate that's on the farthest left. One way to avoid probate in the state of Colorado is if the estate has no real property, so if you don't own any real property, no houses, and your assets in total, I think the number is 90,000 for this year, I didn't actually look that up. I haven't opened a probate yet this year. If your assets are under $90,000, you don't actually need to open probate at all. There's a form, it's a JDF form that's just an affidavit. And the way that works is the person who is the default personal representative, if there is no will, so in the hypothetical we talked about earlier, if there's a surviving spouse, or if there is a will, the nominated personal representative can fill out this affidavit, bring it to, say, a bank that has maybe $10,000 in a checking account, and the bank then has to remit that $10,000 to the person who has the authority, and then they're absolved of responsibility at that point, and the person who received the funds then has to distribute them according to the law. And that's basically cost-free, right? You don't have to do any court filings, you don't have to do any appearances, you have to do nothing of that sort. And there are ways that you can play with assets in, this is why I get paid to do my job, is there are ways that you can have a trust and then create the probate estate so that you don't ever have to open probate and keep assets under that limit. So it's either for people with a limited amount of assets, or it's for people who do more planning and keep their assets out of their personal name when they die. Okay? The middle one, this is where 95% of probate happens in Colorado, is this informal probate. This is this procedure what we have in the state where if nobody comes out of the woodwork and challenges the will, says that the will was improperly written or executed, or that they're saying that nobody comes out of the woodwork and says that the personal representative isn't doing their job, or they're trying to steal money, or something like that, as long as the process keeps going without any issues, it's going to be a cheaper process because there's no judge involvement. You're just filing paperwork with the court to show that you've done these steps. Where things get expensive and where estate planners really earn their living is keeping people out of the formal probate. How do we draft the document in a way that it can't be challenged? How do we communicate with family members to make sure that everybody knows what the decedent wanted? Sometimes that's going to be communicated during life, other times that's going to be communicated after death, but as long as there's a clear message and clear proof that what the decedent wanted is being put into practice, you're going to stay out of that. Formal probate is awful. It destroys families, it costs tens, often hundreds of thousands of dollars. It's just not worth it. So, yes, ma'am.
Can we rewind just a little bit?
Yeah, of course.
I didn't know you wanted questions now, but.
I'm happy to take them at any point, so.
Okay, the dementia part where you're gonna have an affidavit about whether you want to be fed or not.
Yep.
Now, here's another dementia question. In Colorado, there's the MAID program, okay? How can you, in advance, say, I want this, if before you have dementia? How does that work? And tell them what the MAID program means.
I actually don't know the details
Oh,
of that. So
Kimberly
I'm
can
gonna let
tell us.
Kimberly talk about,
What is
Why don't we go to that?
So,
So the,
yeah.
the short answer for you can put an advanced directive, which is really what, a dementia directive is a form of advanced directive. As long as you have capacity, legal capacity to tell the world what you want, you can put pretty much anything in a document that says that you want as long as it doesn't violate public policy. So this is addressing, the dementia directive addresses a very specific thing that says, basically says, I'm looking ahead and I see that there's this potential incongruence between my advance directive and my medical power of attorney. And I know that if I have an advanced demented state, that's not a quality of life that I want. I've seen people do it, I've learned about the lack of capacity and what that means, and that's not a quality of life that I want. And so I don't want any medical procedure done that's going to prolong life in an unnecessary way. So all the Dementia Directive is doing is taking that form of capacity and allowing you to put that in a legally binding contract that doctors have.
I'm talking about the termination of life, when
Yeah.
you're saying, if I can't feed myself, I don't wanna be here.
Yeah.
And that can be included in the directive.
Yeah.
And what does the MAID stand for?
Medical aid in dying.
Medical aid
That's what
in
we
dying.
dealt with Brock, right?
Right.
Yeah, so
Right.
we had a mutual client.
Yeah.
And Kimberly helped guide them through that process that's mandated by the state of Colorado. And Colorado is probably the second most progressive on end-of-life issues. Maybe I think Oregon
Yeah.
is
First.
allows a little more.
Right.
But in this situation, well, I can't talk about sorry, I almost spoke into attorney-client privilege area.
Well, it
You can
volunteer.
speak you can speak generally
Yeah,
about it.
yeah, so all 50 states allow VSED, which is voluntarily stopping eating or drinking to take your life. That's what this woman had chosen to do, so we help support her through that process. But in Colorado, we also have medical aid in dying. So we have more options.
Well, the key, I think, is that the person has to decide and
Why
get
they have
that
capacity.
directive while they have the capacity to make the
Exactly.
decision. Then they can pull the trigger when they want, or they can describe when they want to have the medically induced.
So I think I understand your question a little more now.
Okay.
I can put in a medical durable power of attorney guidelines for my agent around the circumstances under which I do or do not want certain medical treatments. If you really want to specify that you do or don't want specific types of treatment, you do that in an advanced directive, whether that's in an advanced directive form or a dementia directive form. A form is less important as long as you meet the requirements under Colorado law that you state it specifically and that it's witnessed and notarized. I think what you're asking is medical aid in dying in Colorado has a very specific process that you have to adhere to do it. And one of the key north stars to that is competency to be a part of that. So if the question is, can you write in your medical power of attorney that you want your life to be affirmatively ended? No, you can't do that.
Oh, right.
You can't supersede or enact the process in advance on medical aid in dying.
So if you
I'm
get
just-
dementia, you can't use that, then,
Not right
Correct.
now.
period, not
Right
end of
now.
story.
Correct.
Okay.
Yep, and that's a huge area of dispute in elder law and end of life
Yep.
between lawyers and legislators and medical practitioners. And the general principle is if you want to affirmatively end your life by not eating or by going through the medical aid in dying procedures, you have to have capacity, and you have to prove that capacity over multiple interactions with medical professionals in order to do it.
Yeah. Yeah.
So that's the short answer. And I'm not aware of any state in the United States where you can do that without capacity. So, Sherry, you have a question?
Yes, different question, more general question, but what qualifies document as will? Does it need to be witnessed and notarized, or it could be something you just scribble out and give it to the family?
I got a napkin.
An amazing segue to the slide that's on the screen.
Oh.
So, the requirements of a will in the state of Colorado are right in front of you.
In writing.
It has to be in writing. It has to be signed by the person who's offering it. Technical term is a testator, that's from English common law. And it has to either be witnessed by two people or notarized, or both. So here in the state of Colorado, if it's witnessed by two people, it doesn't need to be notarized. If it's notarized, it doesn't need to be witnessed by two people. Okay? Those are literally the requirements. What you'll get to is actually on the next slide about variations of what this means and what happens if you're missing an execution requirement. But that's it. That's what's required for a will in the state of Colorado. So you can handwrite it and have it witnessed by 2 people and it'll be valid. You can type it out, you can initial all the pages, you can not initial all the pages. Of course, you can get into disputes about the validity of a will if it's handwritten and it doesn't look like it's in the person's handwriting. If it looks like somebody else wrote it for them, that can be a problem. If it's not clear that it's one contiguous document, you're gonna have a problem. These are all risk factors, but those don't affect eligibility or effectiveness of the document.
But who maintains it, who keeps it? Like I get inquiry from
there's
families,
no-
like, oh, we have a will, but so-and-so has it in the family, and he's denying that he has it, or something like
Okay.
that.
So there's no registration requirement for a will. You don't have to lodge it with, you can lodge your will with the county, so you could leave it with the Adams County
It's
District
probably a
Court.
good thing to do.
And then you can't deny it.
Candidly, I don't recommend clients do that. It's not a part of the regular document management process. My recommendations generally are keep it in a safe.
Yeah.
Keep it in a safe deposit box. Maybe with your attorney. Those are the 3 that I tend to recommend as far as document management. But
What about a video will?
video wills are not a thing yet.
Not legal.
Not legal yet. Same as we can't do electronic, well, we can do electronic documents within very confined, limits, but they're not the norm yet. The law is slow moving on electronic documents. So I can't wait personally for there to be electronic documents that will make all this a lot easier. Given time, I'm not gonna go into super huge detail on this. I think the components of this that I want to talk through are horror will, holographic will, and we'll talk a little bit about a testamentary trust. A simple will is what we just talked about. It's a person writing something in writing that distributes their affairs, appoints a personal representative, appoints a guardian for minor children if that's a part of their life situation, their stage in life. And it usually includes some language around last remains, whether you want to be cremated or buried. Joint wills, I think I've done 1 in my 9 years of practice. You can write a joint will with a spouse. I don't generally recommend it. Usually you do what are called mirror wills, where they have the same information other than swapping out the spouses. The benefit of a joint will is that a surviving spouse cannot change the terms of one. So you're basically locked into it, both spouses. And that can provide some benefit if there's a possibility of remarriage. That often comes up in trusts as well. So a pour-over will is a type of a will that goes with a revocable living trust. And what that means is, what we talked about trust earlier, a trust is a bucket, and it's a thing that it's a legal entity that you're creating, that you title your assets into it and describe how they can be managed. And it's not uncommon for people to put 90% of their assets or something like that in it, but to forget about 10% or to intentionally keep 10% of their assets in their personal name because it's easier to manage. So think about a checking account. You can have a checking account in Brian Frutig's name, or you can have it in the Frutig Family Trust with myself and my wife as trustees. Every time you go to sign a check for that, you can either sign it as Brian Frutig, or you can sign it as Brian Frutig as trustee of the Frutig Family Trust, dated X. A lot of people say that's just too cumbersome, so they're just gonna keep their checking account in their personal name. So and when you die, you then have, whatever amount of money you have in your checking account. But what you want is that money to go into your trust when you die. And so that's what a pour-over will does, is it says, if you find stuff in my personal name, pour it over into the trust. This comes back to that affidavit that we just talked about earlier. If you have an estate where you intentionally have no real property in your name and you have under $90,000 in your name, you can execute a pour-over will without opening probate. So it can be cost effective and time effective. Okay? A holographic will comes to what Sherry was talking about, which is it's a handwritten will. And it's about, it can also be a will where all of those requirements are not met. Maybe it's not been witnessed by 2 people, maybe it's been witnessed by 1, or maybe it's been notarized, but it's handwritten and it's unclear. It's a process by which you can get that holographic will admitted as a will that the court will accept. So it's a slightly different process. Again, I think the best practice here is to not do this. don't wanna end up in this situation, but if you do, there are ways to cure it so that you can have your intent be manifest by the law. Yeah, they're commonly contested, so often, when we looked at that 3 buckets of probate, you often end up in the formal probate bucket, which, again, you want to avoid because of cost and time and all the other nefarious reasons. A testamentary trust, so people are like, most people see that and their eyes glaze over because the word testamentary is horrible, and they don't understand what trusts are because we haven't gone through trusts yet. The trust we talked about is a bucket that gets created that is governed by its terms like a contract. Testamentary just means it's created at death. So maybe it's death. A death-created trust is a better phrasing for this. Why would somebody want this? Is when I draft things like this, it's usually for contingencies that are not guaranteed to come up, but if they do, they want to manage their things in a certain way. So I think a best example of that would be, I think you showed your hand a little bit about your family, couple, 2 kids. We write the will in such a way that it says, if my children are over the age of 30, I want them to inherit everything equally. That's what the will would achieve. Then the question is, what if they're under 30? If they'll say that they're 22 when both parents died, and they say we want to create a trust at that point to manage those assets until they turn 30. That's a testamentary trust. You can also do that in a revocable living trust, but in a testamentary trust, you're just saying there's no need to create a trust if both kids are over 30, and we expect that we're going to survive past the age of 30. So we don't want to spend the money to create a full trust with all of its caveats and all of its detail when we can just create that in a will. Okay. I feel like I've lost the audience with the level of detail I'm getting into without the structure, so I apologize if I'm losing people on that. Let's skip over this. So what is a trust? Let's come back to a trust. The key attribute here, I think, is in this. So a trust. So let's phrase it this way: when you own a car, you have the ability to drive that car. You also have a responsibility to pay for maintenance, change the oil, get it in for its regular appointments. So those 2 examples are combining the 2 forms of ownership that are separated in a trust. The first is the beneficial use of that is the driving around and the enjoyment of driving your car. The legal obligation to maintain it and keep the license plates up to date, the emissions testing done, that's all the lawful or the legal part of that ownership. What a trust does is it separates those 2 concepts. So when you create a trust, you created a legal entity, which we said a couple times. And then what you've done is you say, who has the right to manage the assets, to be legally responsible for managing those? The name of that is called the trustee. Okay? The trustee's job is to protect, to make sure that all the assets in there are being managed and not wasted, and to secure them. So if it's let's say it's a gun that we have in a trust. The gun needs to be kept in a safe, and it needs to be kept away from people who are going to use it improperly. And that's the legal responsibility of having that gun in there. Then the trust is also going to say who has the right to use that gun. Who has the right to go pull it out of the safe, to use it for secure safety, or who has the right to go hunting with it. Those are the beneficiaries, okay? So again, what we're talking about are the different attributes of the different people that a trust names. So we have trustees who manage, beneficiaries who have the right to use the things. Okay? That applies with money just the same. We're talking about an investment account that's held by a trust. The lawful responsibility is to invest that money in a prudent way that matches the interests of the beneficiaries. So if I have $100,000 in an investment account and my beneficiaries are 25 years old, I can invest that money moderately aggressively. If I'm holding that money and my beneficiary is 80, I want to have that in a pretty conservative mix of bonds and cash equivalents.
Can we go back to the car example?
Yeah, go ahead. Yeah.
Okay, so somebody puts their car in this trust.
Yeah.
and they have the right to keep driving the car. Are you saying the trustee takes over making sure that you change the oil, that the oil gets changed and that kind of stuff?
Technically, yeah.
Who would want that job?
So this is where we come back to, so in reality, for a revocable living trust, I'll use myself as the example, again, married, no kids. If I had a trust, during my life, I am the trustee and I am the beneficiary. So nothing really changes about how that
You
happens.
are the trustee
Right.
and the beneficiary.
It's typically, while you're living, if you have a revocable living trust,
Okay.
for
Yeah.
the people that create the trust to be both the beneficiary and the trustee. But I think what you're leaping ahead to is also, how can a trust be beneficial to help people as they age if they start to be unable to manage the affairs that are owned by the trust? So,
So
I
then
tend
the
to go
trustee has to
personal
really
real quick,
work.
but, so my dad just passed away. I don't want, it's just, he had dementia for a long period of time. He, at about age 75, stopped being able to manage his affairs. And my mom was doing all of the management of his affairs. When we got to that point, even though, so because he lost capacity, he could no longer be the trustee on his trust. So my mom was the sole trustee, my dad was still a beneficiary. And so maybe the car's not a good example because he wasn't driving around using it, but the assets that were in the trust could be made available for his benefit to be managed by my mom, who had capacity, for his benefit. But when he was 65, he was both a trustee and he was a beneficiary. So that's where trusts play a role in supporting people in an elder law context, or as we age, it's an effective way to give somebody else control of assets for somebody else's benefit. And it's more, I would say it's more effective in many circumstances than a financial power of attorney.
So how did that trustee go from your dad to your mom? Was that a court process? Was that, no?
So in a trust, you appoint, just like you do with a will, where you appoint a succession of personal representatives,
Okay,
you appoint a succession of trustees.
okay.
And for joint trusts, the most common way to do it is both spouses are trustees to start. If one spouse loses capacity, the other spouse is sole trustee. If both spouses lose capacity or die, then you have a successor trustee. And you can appoint whoever you want to do that. It can be a child, it can be a friend, it can be a professional trustee, it can be an accountant, it can be an attorney. There's no limits on who it can be, but that's critical to the successful administration of the trust, is to have a clear and just a clear succession of who can step in and be responsible.
And who determines incapacity in the case of dementia?
The document itself defines incapacity and when it gets triggered, and it also defines who has the right to trigger it. There are a number of different ways to do that. If you want to be, those just range from, depends on what your priorities are. I don't typically draft it this way, but the most conservative way you can draft it is to require a doctor's note, doctor's certification that somebody cannot manage their own affairs. I would say that I typically draft it in a way that it is more, it's easier to administer. Usually it allows if there's co-trustees, it allows the other trustee to make the determination, but gives the person whose incapacity is being called into question a timeline to challenge it with the doctor's note. So it puts the emphasis on easing the transition rather than forcing a doctor to get involved. Because doctors sometimes are a little hesitant to declare incapacity.
Yeah, they're very hesitant.
Yeah. So I like to do it in such a way where it can be managed within the family first, but it provides, if somebody's going to challenge it, they have a recourse that's defined in the document that involves a professional to make that choice. But the short answer is, it's one of the beauties of a trust, and it's also one of the things that makes trusts harder to explain, is they're really flexible. They're essentially contracts between the people that draft it and their future beneficiaries. And they can define that however they want. And that's where you want a lawyer to be involved to help you craft the language in the right way and have the lawyer explain to you what are the pros and the cons of using specific approaches. It may have been fulfilling answer, but I hope that came close.
No, I think that clarifies slightly.
Okay.
The only irrevocable trust I've seen, and this is why, one of the reasons I get confused. So my dad ended up, for a time in his life, qualified for Medicaid.
Mhm.
But he had prepaid for a burial plan
Mhm.
with Ohlingers, you know. That was put in an irrevocable trust.
Mhm.
So when he qualified for Medicaid, that stayed in place and it wasn't counted as an asset.
Mhm.
That's the only way I've ever seen anything like irrevocable trust, so, yeah, it gets confusing when you only see one aspect. It's hard to grasp, at least for me, what a trust actually is.
That makes 100% sense, that makes sense 100%. God, I can't speak today. Trusts are really complicated, and I've intentionally, the dynamic of separating legal and beneficial ownership, that's all essential to any kind of trust. But when estate planners are talking about trusts, most of the time they're talking about revocable living trusts as opposed to different irrevocable trusts.
Oh, okay, all right.
Irrevocable trusts are for very specific purposes. Many of those have to do with tax avoidance, and for the vast majority of people in today's climate, in today's tax world, tax avoidance is not a driver of doing a trust. So let's just make that really simple.
One can be changed.
Go ahead.
One can be changed
Right.
by you, it's revocable, and the other can't.
Correct. Yeah, that's the main difference. The way that manifests is when you do an irrevocable trust, you're appointing someone else as the trustee, a third party, who's not subordinate to you, not, that you can't overrule, basically. For a revocable trust, yeah, you're retaining certain powers that enable you to put assets in, take assets out, to change the language of the trust. The trade-off is that you don't get any. What I say is there's a trade-off between control and protection, asset protection. You get more asset protection if you retain less control. So if you have an irrevocable trust where you don't retain any control, all those assets are protected. And what are they protected from? They're protected from liability. They're protected in certain circumstances from being included in Medicaid eligibility considerations, as long as it's been done 5 years before. So this is where we're bleeding into Medicaid a little bit. You used to see the forms of irrevocable trust that were more common 10 years ago than they are now are irrevocable life insurance trusts, ILITs. And those were so that you didn't include your life insurance proceeds in your taxable estate, so that you avoided estate taxation. And that was when estate taxation was, $1 million or $2 million, whereas right now, every person in this room has a $13.99 million investment. So if you double that as a couple, it just doesn't catch that many people. I have a handful of those in my client base, but 99% of my clients is just not a consideration.
One quick question.
No.
When you go to probate and you have this list of all your personal reps, isn't it good, because here, what if they disagree and challenge you or whatever, and if you don't have it, like, maybe you should have them all listed on the probate, all the different options, because what if, when it gets to this point, the beneficiaries disagree with whatever the last will and testament
So
says.
you're talking about this, right?
Yeah, your probate, the list that you have appointed people as personal reps, maybe it needs to be inclusive of more than one person.
100%. My recommendation at a minimum is 3. So I recommend you a 3 deep on every fiduciary. Again, horrible word. Every person that's in your team, I recommend you go 3 deep on them. Some people don't have 3, so they go 2, that's okay. But you always want some redundancy. not just your spouse or one person, yeah, I can do it.
I just, if anybody needs to leave, I know we're at the top of the hour, but if Brian, if you're able to continue, that's wonderful.
I have plenty of time, and I apologize,
Okay.
this has been a little disjointed,
Well,
but
answer
also,
questions.
I'm here to answer your questions, that's my main goal.
Yeah,
So, but no, to your point, 100%, my recommendation, whether you're talking about a personal representative, or a trustee, or a medical agent, or a financial agent, or guardians for minor kids, you want redundancy built into your plan. And what I tell people is, yeah, I tell you 3, but if you know 6 people in order that you want to be responsible for taking care of your kids, there's no harm in listing them, right?
Brian, I was just told contractors are gonna be here at 11:15,
Oh.
so maybe we wanna
They'll be here
get
at
it.
11:30.
Oh, 11:30, okay, so if
Okay.
we wanna get into briefing or whatever.
So,
Let's say, just a quick question, let's say you don't have any beneficiaries and you wanna leave like your estate, maybe it's a home, and have them sell it and have all the assets go to like the Boys and Girls Club via scholarships. Would that be a charitable trust?
no, not
No.
necessarily. You can make charitable gifts within a will.
Okay, so it could
Just a
still be
standard
a
will.
revocable living trust?
You can also make charitable gifts through a trust, yeah. So charitable trusts are, what I'm referring to as charitable trusts here are a very specific kind of charitable trust. They're called annuity trusts or uni trusts. And those are ways in which you can take a tax benefit now by making a gift to a trust. Then you define later how, in the annuity form, what you're doing is you're saying, I'm gonna put, say, $100,000 in a trust for charity. But I'm gonna retain an annuity interest, so I'm gonna take a cash payment every month for the next 5 years. And at the end of the 5 years, the remaining principal gets paid to charity. That's what a CRAT does.
That sounds
A
good.
CRUT is the reverse of that. It says, I'm gonna give some money to charity, I'm gonna give a monthly amount to charity out of this amount, but at the end of the period of time, the money comes either back to me, or in most cases, it comes back to family members, so it'll come back to children. And it's a way that you can take advantage of the tax system to get a tax benefit now and have the money both benefit charities and benefit the families in the future. As
Otherwise,
opposed, go ahead.
if you don't do that, how are you taxed on all of this when you pass?
Well, so
Is your
you're not
whole-
penalized for charitable gifts under gift tax law or estate tax law. So if under what you said, if you want to make a gift to charity now, you can just make gifts to charity.
Well, it could be under your last will and testament.
Or if in your last will and testament, you say, on my death, I want to divide, and again, I don't know your family situation, let's say you want 50% to be divided between your children, and 50% you want to go to the Boys and Girls Club. That's a gift out of your estate that your personal representative would make directly
So
to
it
the Boys
doesn't have
and
to be
Girls
in a
Club.
trust then? Okay.
In fact, that's incredibly common. Yeah, where I like trusts, where you can do slightly different things, is let's say there's a couple, and they are charitably inclined, and they want to make specific cash gifts on the death of the first one, then they also want to leave a remainder gift on the death of the second spouse. You can start to spell out or stage out how you do your charitable giving in that way. So let's say I wanted to give $50,000 to the Boulder Humane Society on my death, but I want everything else in my estate to go to my spouse. But when my spouse dies, we want to make another $100,000 gift to the Boulder Humane Society. A trust is going to be a much better way to do that than a will, because you can coordinate it all in one document.
I see.
And it's also not, if you draft the trust in a specific way, the spouse can't change that either.
And does that charitable organization usually have things like that in place to help you develop that trust?
Can you say that one more time? I'm
Like
sorry.
Boulder Humane Society, would they have like a legal entity process that can help you with that?
As far as making the gifts, yeah, they usually have a whole division of the nonprofit. Depends on the size of the nonprofit, but they'll usually have somebody that's responsible for both plain giving and during life gifts.
Okay.
They have an EIN number, you want to include all that. Then the other things you can do is, let's say, I helped a client with this last week actually. They wanted to leave a gift to an educational institution.
Would that be considered a charitable trust then? No, they don't do that.
I mean, you can have charitable agreements with specific institutions as well. So you can make a promised gift with them as essentially a contract. So it'll function similarly, but that's different than what I'm talking about with the charitable trust.
Okay.
But I guess what I'm saying is, if you, let's say you wanna leave a gift to a charity or a nonprofit for a specific purpose, and force them to use it for that purpose, you can includes very specific language that says, I wanna leave this money to this educational institution for this particular program. If that program is no longer in existence, then the money doesn't get gifted. So you can put requirements on it that they have to observe. Okay. All right, on the Medicaid side. I have, 15 minutes? Love trying to, let's see, Medicaid. So, when I'm talking about Medicaid today, I'm talking specifically about long-term care Medicaid. Medicaid is a huge, huge governmental entity that has federal components and is administered by the state. It has programs for impoverished individuals. It has programs for different waiver programs that have to do with specific illnesses, disabilities. It has programs for disabled and blind. It has all kinds of programs. I'm not covering every single one of those today. I'm focusing on the part of Medicaid that applies to ensuring people can have nursing home level of care if they meet the medical need and they meet the eligibility requirements. Okay?
Just to, is there like, I know it's for low income, but what is the level for Medicaid? Or sometimes they can have both, I guess, Medicare and Medicaid.
So Medicare they often get confused. Medicare is a health insurance plan for over 65. So if you're over 65, you get that. You can be dual eligible under other programs if you're under 65. But what I'm talking about specifically is for like housing, like nursing, getting access to a nursing home, right? And who pays for that if you can't pay for it?
I got it.
That's why I went to this slide immediately. These are, so there's gonna be 3 slides. The first is for single people. The second is for married spouses, both spouses applying for Medicaid. And the last is married couple, but only one spouse needs that level of care. And there are different eligibility requirements for each one. These are 2025 numbers. So, and it's all predicated on you needing that level of care. So, here's the medical standard. This assumes that you have that. And so, nursing home level of care requires, this means that you have physical or functional health ability or behavioral problems that mean that you need around-the-clock support. If you don't have, you have to be under these requirements in order to qualify. Income, you have to be under $2,901 per month. If you're over that, there is a way to get it, to become eligible. That's called a Medicaid income trust.
Does that include disability income, SSDI, for income?
SSDI is equivalent to what you would be entitled to under Social Security requirement, and yes,
Right.
it's included.
Okay.
The asset limit is unchanged since like the 80s. I think it's the last time they changed it.
Oh my
And
goodness.
it's punitively low. It's $2,000 per person. So again, you have to be basically impoverished in order to be eligible for Medicaid. There are carve-outs, which we'll get into when I get to that slide. And you need your nursing home level of care. If both spouses are applying, the numbers are double for income. For assets, they allow you $3,000 or $4,000 if you're staying in the same room. And this is where it gets the most complicated, is when you're applying for one spouse, but the other spouse is what's called a non-institutionalized spouse. And the big number here is the safe harbor for $157,920 for the non-applicant. So really, The total number of assets that you have to be under for you're applying for one spouse and not the other is 159,920.
Does that include equity in your home?
So
That's
homes
what I was
are,
looking at.
homes are tricky, but the short answer is yes. So let's, income's really quick. To answer your question about whether SSDI is included, basically anything's included. The only thing that I'm aware of that's not included is VA aid and attendance dollars are not included as income for the income calculation, but everything else is gonna be included, including in Colorado, IRAs, 401ks, which to me is fairly punitive. There are some states that do not include that, because it's not liquid necessarily, and the penalties for pulling out can be hard. But basically on the income side, everything's included. Where it gets a little bit complicated is that scenario where you have an institutionalized spouse and a non-institutionalized spouse, and how do you both what is included and if the person who's non-institutionalized has income under $2,555, you can top up to get to that number using the institutionalized spouse's income. The way that works out most of the time is with Social Security. You can then take a certain amount of the Social Security of the one who's in the nursing home and move that over and just deposit it in the non-institutionalized spouse. There's no penalty for either eligibility or removing their eligibility going forward. Again, income's pretty simple. And what I said is, if you have more income than Medicaid allows, you can qualify, you can still get Medicaid care by doing what's called a Medicaid income trust. And the way that works is it is an irrevocable trust where all the money that the institutionalized spouse earns gets put into this account and then gets given to Medicaid, and then Medicaid pays the difference between that monthly amount and their monthly amount for the nursing home. So to use round numbers, let's say that there's $3,000 that are earned by the person who needs the care, and the cost of care is $10,000, Medicaid would pay the $7,000 difference, not the entire amount.
And who draws up that type of trust and when is it drawn?
So there's actually, I do draft them, but there's also just a form that gets filled out.
It's filled out when it's needed.
Yeah, the cheapest way to do that is gonna be to apply for Medicaid through one of their, single point of contact, single point of entry to the system, and they'll have a one-page Medicaid income trust that you can fill out.
Okay.
To do that. And what I like about that is you don't have to pay somebody like me to do that. There's no reason you should pay me at my hourly rate to do that kind of basic detail. Of course, if people are confused about it, I can consult them on it as to what it means, but you don't need somebody like me to draft that up.
But you still have to be under the $2,000 asset.
No, yeah, you still have to be under the asset limit for sure.
And your home, if you have a home, it counts as an asset.
So, houses are weird.
Houses are weird.
So, that's why I came here. So, let's start with the basics. So not all assets are countable. That's the first thing. So
Okay.
the question is, what are non-countable assets? Non-countable assets are all of your personal belongings, all of your household furnishings, one automobile, irrevocable burial trusts. So if you prepay for burial care or anything like that, that's not going to be included. And your primary home is not countable. Put a big asterisk next to that. The first asterisk is that it is not countable up to $1,097,000. If your equity in your home, so that's a great number. That's a big number, right? That's good. The downside is if you own a house, doesn't apply to me. If you have a $1.5 million house that's paid off, the difference between 1.5 million and 1,097,000 is going to be considered an available asset, and you would be over the limit. So how do you pull that money out? You work with a reverse mortgage professional. There are lots of different ways to pull that. You get a home equity line of credit. There are lots of ways to pull that equity out to use it to pay for the care of your loved one. So the good thing about having the house not included as not being a countable asset is it doesn't stop you from getting access to the nursing home level of care, right? So we get the first. I tell all my clients, my first priority is getting your loved one the care that they need. We'll worry about the monetary challenges later. So this is good because it gets the loved one the care that they need in an environment where they're gonna be protected and safe. The downside of this is, and this is the big asterisk, homes are the only asset where Medicaid puts a lien on it. And so if you go into a nursing home and you run up $500,000 worth of care paid for by Medicaid, when you die, they will force your estate to sell that house, and they will, and the first $500,000 will go to Medicaid, and then the remainder will be distributed amongst your heirs or devisees under your will or your trust. Okay? So it's not off the books.
So even though your home was exempt, like if it was just valued at $1 million, so that was exempt during your lifetime, if you then go into a nursing home and you do that's the $500,000 in this instance, they would put a lien on that, is it, okay? All right.
Yeah, and so then the question is, unless there are circumstances where the state policy says we're not gonna come after your house. So this all has to do with, Medicaid's look-back rule and it's called the Medicaid Estate Recovery Program.
Okay, so the income asset trust only applies to your income, not equity?
Yep.
Okay.
Equity is an asset, not an income.
Gotcha.
So what are circumstances where a house can be kept so that Medicaid won't come after it? First is a relatively easy one. If you are a spouse and your spouse is alive and your spouse doesn't need nursing home level care and the spouse lives in the house, they're not gonna come after your house. Medicaid estate recovery doesn't apply. Another situation that I run into a lot is a child lives in the house for a statutory period of time, and they've provided care to keep the person out of a Medicaid nursing home for a certain period of time. Medicaid's gonna say, we're not gonna come after the house.
Can the child be 50?
Sorry?
Can the child be 50 and
Yes.
still cover?
There's no limit on age.
If they're taking care of you, yeah.
62.
3-year-old's not gonna take care of you.
The public policy there is to say, if you've shown that you were providing caregiving support to somebody and you were living in that house with the one who ultimately needs long-term care, but you kept them out of the long-term care program under Medicaid, we're gonna incentivize that. We wanna incentivize that behavior. So we're not gonna penalize you by coming after the house. Okay. There are a few other examples like that, but those are the two main ones that are ways to make it so that Medicaid estate recovery doesn't apply. Okay. Any questions about any of that? The other component that I always like to talk about is Medicaid's look-back rule. And this will be what this means is Medicaid goes back, when you apply for Medicaid, they ask for all of your transactions out of all of your accounts for a 5-year period. And anytime you transfer an asset out of your name to somebody else at an amount that's less than fair market value, that's gonna be considered an unlawful transfer.
Thank you.
So, if you do it, if I make a gift of, say 20,000, let's say I make one at the gift tax, say I make a gift of $19,000 this year to somebody else. If I apply for Medicaid next year, they're gonna find that transaction and that's gonna be an unlawful transfer. If I make the gift now and I don't need Medicaid for 6 years, they're not gonna find that transfer and I'm not gonna be penalized for it. So you have to be really mindful about when you make certain transactions, to make sure that you're not gonna be penalized for it when it comes to applying for Medicaid. And the reason they do that is they don't want people making gifts just before they apply and taking things off of their personal books and making the taxpayer pay for their long-term care. So, yes, ma'am?
Would that apply if you have a beneficiary deed on that property?
So a beneficiary deed applies when you pass away, not while you're living.
Yeah.
So
With
it's not gonna
Medicaid.
affect this calculation.
I think you're asking, can
About the
Medicaid still
lien?
come back after the house?
I mean, with Medicaid, yeah.
Yes.
pay for the bill.
Medicaid's lien right on your property will supersede a beneficiary deed on a property.
Will it supersede the first mortgage too?
Yes.
So if you have a reverse mortgage, Medicaid's gonna get paid first before the, mortgage payment.
Medicaid and the IRS have two of the highest priorities of payment under debt systems.
Of course they do.
So,
Yeah, okay.
all right, so I've been told that we're out of time. I apologize for the disjointed nature of the presentation of the slides, but I do hope that I was able to answer all of the questions that were raised, and I hope that, I'm sure if anybody asked that, everybody else was thinking it as well. Again, my promise to you is I'm gonna stick around after and answer as many questions as people have. I'm not running out. But thank you so much for your attention. Thank you for giving up so much of your time. And thank you for inviting me this morning. You guys have been awesome. My cards are on the table at the back. Sorry, back in the, right by the entrance, yeah.
And just everything for coming, if you grab one of these, this is our whole series for the rest of the year. So we do it on the second Wednesday of every month. So next month we'll be talking about right sizing and downsizing. So please grab some information on your way out.